Welcome back to part 2 of this presentation. Be sure to like and subscribe, and I encourage you to share this video with your coworkers so long as you're sharing this video and watching this video while you are not on the clock. In this presentation, we will be covering basic principles when dealing with human resources. And finally, we will be going over protections, venues, and timelines. This information provided in this video is for general information purposes only. If you need a union representative, please be sure to reach out to your local union office for assistance.
And some of them are being recruited. Creatures are trading wealth, power.
You mean people are joining up with them?
Most of us just sell out right away. Then all of a sudden we get promoted. Our bank accounts get bigger. We start buying new houses, cars. Perfect, isn't it? We'll do anything to be rich.
Obey now, grieve later. Also referred to as comply now, grieve later. A general rule is that employees are expected to follow management directives. If an employee believes the directive to be unfair or a violation of the contract, he or she can file a grievance at a later date. The exception to that is, of course, if the manager's order would have an adverse effect on the health, safety, or welfare of yourself, your coworker, or any other employee, or non-employee for that matter. Failure to follow management's directives can result in disciplinary action, most commonly insubordination. Let's see what the contract has to say about this. Let's turn to page 63 of the Master Agreement. Under Article 17, Employee Rights, Sections 11 through 13. Section 11, Unlawful Orders. An employee has a right to refuse orders that would require the employee to violate an applicable law. The employee will promptly bring his or her specific concerns to the supervisor or appropriate department official. The department official will consider the employee's concern and promptly notify the employee whether the order is lawful or unlawful. Refusal to obey an unlawful order will not subject the employee to disciplinary or adverse action or major adverse action. Section 12. Improper Orders. An employee has the right to question an improper order that would direct him or her to act outside the scope of practice, privileges, competencies, or qualifications. The employee will promptly bring his or her concern about the improper order to an appropriate supervisor. The supervisor will promptly apprise the employee whether the order was proper or improper. A refusal to obey an improper order will not subject the employee to disciplinary or adverse action or major adverse action. Section 13. Conflicting Orders. When an employee receives conflicting orders, he or she will bring the conflict to the attention of the supervisor who gave the last order, or another appropriate supervisor. The employee will be given a clarified order. The employee will not be subject to disciplinary, major adverse, or adverse action for following the clarified order. Remember this phrase: I invoke my right to union representation. If you have to stand in front of your mirror and repeat it 100 times in order to memorize this phrase, it's going to be worth your time. It may one day save your career. I invoke my right to union representation. Sometimes referred to as your Weingarten rights, and that is because of the Supreme Court case from 1975, NLRB versus Weingarten. The findings of that Supreme Court case were incorporated in what we now have as 5 U.S.C. 7-1. An exclusive representative of an appropriate unit in an agency shall be given the opportunity to be represented at any examination of an employee in the unit by a representative of the agency in connection with an investigation if the employee reasonably believes that the examination may result in disciplinary action against the employee, and the employee requests representation. In other words, what this is saying is that if you're a bargaining unit employee and a manager is asking you questions, in other words, interrogating you, and you believe that by answering those questions you can be disciplined, you must first invoke your right to be represented in order for you to have that right. Failure to invoke your right to be represented by the union is in essence you waiving that right, and the agency is very cognizant of this, and they're trying to avoid getting hit with a ULP, an unfair labor practice charge. And one of the things that they're trying to do is they send a waiver to you asking you that if you don't want to have the union present, please sign this form. Sometimes they don't sound that nice, but you get the point. It is foolish to think that by waiving your right to union representation that the outcome would be any better. By invoking your right to union representation, that in itself is not an admission of guilt. Therefore, it's foolish to waive your rights. The agency is supposed to be notifying all employees of this particular right at least once a year, per the statute, 5 U.S.C. 7114. In some instances, the agency is posting the notifications in the break rooms. It's just that nobody ever reads them. And in some instances, they may be emailing it out. And there are other ways they can inform employees so long as they're meeting that obligation. If this is the first time you're hearing about your right, and you have never received an email, and it was not posted in your break room, I would file an unfair labor practice charge. I would go to the union official and ask them to file a ULP. If they don't want to file a ULP, then you as an employee have the right to file that ULP. And perhaps in a future video, we will go over how to file an unfair labor practice charge. But don't feel that by invoking your right to union representation that you are admitting any wrongdoing. That's not what this is. Human Resources works for the agency, or more appropriately, Human Resources works for management. And if there is one lesson that is to be learned, is that management is management is management is management. HR makes employees feel that justice will be done. HR will make you feel like you were heard. And sometimes employees ignorantly walk over to the HR office and put in a complaint about their supervisor, feeling that the HR officials are going to hold their managers accountable. That's not always the case. Management has a union, but they don't call it a union. They go by different terminology. Employee relations, labor relations, and employee labor relations. They work for the HR director in most cases. They work for management. And so they're also the ghostwriters and the advisors for your management. So whenever your supervisor needs advice on holding you accountable, for example, your supervisor will pick up the phone and call up someone at the ELR office and say, my employee did such and such, and I need to know what to do. And in some instances, ELR will ghostwrite their disciplinary documents and help them put their disciplinary supporting documents together, because they know the disciplinary process better than anyone at the VA. Therefore, if you ever get a call from ELR, your spidey senses should be going off to Richter. Know that HR works for management. And if you're having an issue with your manager, your supervisor, you should reach out to the union for assistance. However, if you're having an issue with another bargaining unit employee, that situation falls under the jurisdiction of your supervisor to resolve. That's an agency problem. So remember, Management is management is management is management. Protected classes and protected activities. A protected class is what makes you who you are, and protected activities are things that you do. Both are protected by law. The agency should not be acting against you based on any of these classes or activities. Each one of these can be a PhD dissertation unto themselves. And this list is not all inclusive. Protected classes are things such as your race, color, religion, sex, national origin, age, disability, or genetic information. Within the meaning of sex is pregnancy, gender identity, and sexual orientation. And within the meaning of age is 40 years of age or older. Under protected activities, there are union activity, whistleblowing, jury duty, filing an EEO complaint, resisting sexual advances, answering questions during an employer investigation of alleged harassment, filing or being a witness to an EEO charge, complaint, investigation, or lawsuit, requesting accommodation of a disability or for a religious practice. It is extremely important for you to become familiar with these legal protections. Congress put these laws in place in order for you to not be afraid to engage in these activities. It's important that in the government there are whistleblowers in order to expose fraud, waste, abuse, corruption. And those protections are put in place for employees to engage in those actions without fear of reprisal. Same as jury duty. Jury duty is something that is a civic duty. And the agency should not be acting against you, should not be retaliating, and should not be reprising against you because you're engaged in these activities. You should not be afraid to file an EEO complaint. And if you are a witness to an EEO complaint, you should cooperate with that as expected. Unfortunately, a lot of people feel that if they cooperate, that they will feel reprisal and retaliation from their supervisors. The truth of the matter is, if they don't engage in that EEO investigation, for example, they don't have the protection of being a witness to that event. And the same is true with situations regarding religious accommodations and disability accommodations. You shouldn't be afraid of having to request those accommodations. And if the agency acts against you, you should understand that you were engaged in these protected activities, therefore you would go to the proper venue. The proper venue could be EEO, the proper venue could be the FLRA, the proper venue could be the union grievance procedures, or it could be the Office of Special Counsel, it could be a myriad of other venues. However, it is extremely important for you to understand these are legally protected classes, these are legally protected activities. The agency should not be violating the law. And if they do, this is where you go to seek remedies. Union activity is protected activity. Examples of protected activity include but are not limited to filing a grievance, seeking union assistance, obtaining union representation, discussing the collective bargaining agreement, and other representational matters in the workplace during non-work time where it does not disrupt work. And that would include discussing this YouTube video with your coworkers, so long as it's done outside of your duty time. Is the grievance always right for every occasion? The answer to that is no. It's important to understand what the issue at hand is first, and then to make a good, educated determination as to what venue you would like to proceed in. Not everything is a grievance. Sometimes you have gripes in that you didn't like something, but there's no contractual violation, there's no statutory violation, it's just a gripe. Or it could be an unfair labor practice, or it could be an EEO charge, or it can go to the Office of Special Counsel, or to other venues. it's important to understand your options, to understand the nuances, to understand the timelines, to understand the past success and failures. This is very important, or you're going to end up losing the case. If not losing the case, you may end up in a venue that will take you an extremely long time for your case to be eventually won, but then you've wasted a lot of time waiting where it could have gone faster. Timeliness, timeliness, timeliness. It is extremely important for you to know these dates by heart. 30 days to file a grievance, 45 days to file an EEO, and 6 months to file unfair labor practice charges with the Federal Labor Relations Authority. I am hoping that by spreading this information and by making these videos, we will make the Department of Veterans Affairs a better place to work at, and this is considered protected activity because it is concerted activity. And I hope that you will share this with your coworkers and educate as many people as possible, because the more that we're able to practice our rights and to invoke our rights and to let management know that they won't trample our rights, the better workplace we will have. Thank you and have a great day.